Field of expertise are bank products, especially missold bank products, he'll put me right, and bank guarantees, which have affected a lot of people who've been buying off plan.
Hello, good evening everybody. As Mija has said, my name is Rafael Ramos. I work as a lawyer in the litigation department in Martínez Echevarría Law Office. And well, one of my field of expertise is lawsuits against banks. Okay, banks, you probably knew that they are not charity entities, but most of people really go to a bank as if they were their friends. They have a very good relationship with the manager. They really trust the people there. That is something that is very usual with the Spanish people, but I guess that it's not only limited to Spanish men and women, and it's also happening to people who live here, who are resident here. So you have been included in all the problems that we have had with banks in the last years. We all know that banks are one of the main source of our problems here in Spain, and I guess in the whole world. But in Spain, it has had a special point which made them different from some other countries. And it is that in Spain now we don't, but we had two different kind of banks. Normal banks and saving banks, which now they do not exist. But at some point they were here, and they had the special things that they didn't have shares, they didn't had their values in the stock market. So at some point when the crisis started, they needed at some point to get funds from some place, some source. And what they decided is to sell some products which were initially thought for investments, for investors who were in a very strong position, and not for people who had their savings here in Spain. But in the end, they sold these products to everyone. I'm talking, about the preference shares, about the obligation about the subordinate bonds, and also about some product called the swaps, which were sold as some kind of insurance of the mortgages. All these products are completely abusive and completely out of reach of a normal people who had their savings here and just wanted, to put some money in a secure product and get some rent from that product. The main issue that we have had here is that because of the crisis of the banking system, most of them have disappeared. Most of them have been converted into normal shares, but with a loss of their value. And it is something that at the beginning were a huge problem for a lot of investors. It's something that really people couldn't fight against it. In Martínez Echevarría, we started to fight against this kind of products about 2-3 years ago, and I have to say that we have had a great results with that. The truth is that in most of these products, the formalities that they had to be carried out weren't carried out. For example, I have had a lot of cases in which English people were not even translated about their rights. They have signed a lot of things in Spanish when they just didn't know Spanish. I've always had a lot of people who didn't sign a special test that is mandatory to do, a test about the ability to understand and to invest in some kind of products. But in the end, our courts are saying that these formalities are not enough. I mean, you may say, I have actually signed all of this, I signed it in English, so everything is okay, and I can really do anything against this. But the truth is that most people, Spanish or not, they really were not explained which was the kind of product that they were assigning. Most of them thought that they were with deposits or bonds or normal products, completely secure, and they were assured by the manager of the branch that they were completely sure. Thank goodness, our courts are saying that the signing of these documents is not enough. There has to be some good explanation of the kind of product and a complete and exhaustive explanation of what was the product. in which case, in most cases, I have to say, not even the managers knew exactly what they were. I know this very, very good, because they are really very complex products, and so we can really fight against these products because they have missed all these formalities, and they have missed the necessary clarity and transparency that it was needed, and they really never explained almost anybody which was the real nature of the product. Also, a second field in which the banks started to abuse, especially from the year 2008 until today, was because of the inclusion of some abusive clauses. One of them, the most important one, is what is called the collar of the floor clause, in which they limited when you sign a mortgage. It was very typical to sign it with a variable rate, but the banks included a clause in which the rate had a lower limit. So you can go with the rate as high as 15%, but you cannot go lower than 3.5 or 4 or even 5 in some cases. This floor clause was actually introduced in most mortgages, not only at the beginning of them, but in the year 2007, 2008, because they knew that the Euribor, which is the typical interest rate which is used, was going to drop, and they did, and we are now in this problem. Thank goodness, again, we lawyers started to fight against this abusive clause, because it is very clear that with this kind of clause you are changing the nature of the mortgage, because you are buying, let us say, a variable mortgage, and you think that you're going to benefit you're going to suffer, when the rate is high, but you're going to benefit of this dropping of the rate. But with this kind of mortgage, you're really buying a fixed rate mortgage, which can only go high. So it is clearly a fraud, and it is something that we can fight against this. We have a lot of court decisions about this. Almost most of them are positive, but we even have a very important decision of our Supreme Court last year, May the 9th, in which they declare the nullity of this kind of clauses, because they lack the necessary transparency, are conditions which are essential to the financial system. The truth is that our legal system is very protective of the consumer, but this protection, which is ruled by the law, until the last 3 years has very rarely taken into consideration by the court, not because they didn't want to, but because the consumers really didn't defend their rights. Now, of course, the situation went so bad that a lot of people claim for their rights, and we have these decisions in favor of the consumer, which really help us to get the justice for them. Okay, so I have this kind of product, I have this abusive clause in my mortgage. What can I do? You may think that, like in Britain with the PPI, that the bank is going to contact me to remove it, or that you may write a letter to the manager or to the defender of the client. They are going to remove it, and I'm afraid not. They are not going to do anything by themselves. And if you send them any kind of formal letter, they are not going to do anything. And even if a lawyer sends them a letter, they are not going to do anything about this, because they are playing with numbers. Of course, if they remove these clauses, if they have to refund the money of these illegal products, they're going to lose a lot of money. So they are playing with numbers. Okay, let us say that 15-20% of the people claims against me, but I still have the remaining 80% that they are not going to do anything, and I'm going to win to still keep that money. So I'm afraid, and I'm sorry to say that the only way in which you may get this money back, or for example with the floor clause, to get a benefit of the drop of the Euribor, is by starting a lawsuit against the banks. Now we have a positive attitude by some of the banks in which they don't want any more legal court decisions against them, and we are getting an agreement once the lawsuit has been filed and the process has started. But the lawsuit has to be started. I'm afraid it is not. They are clearly playing with the people who are not going to defend the rights, and they are going to keep their money. So that is the situation we have here. And now it is a great moment to do that, because I mean, I'm not going to say that the court has not been sensitive to consumers in the last years, but now, in the last year and a half, they're especially very sensitive about the problems of the consumer. And I have to say, of course, if you don't have a legal case, and you don't have the proof, it is something that you cannot claim. But now, if you really have the case, if you really have the necessary proofs, you are going to win the case, and you are going to find the favor of the judge to get a positive decision for you. I, at some point, understand that judges are also people, and they also may have a floor clause or a friend with this kind of hybrid products which are completely illegal, and they are specifically more sensitive because they are also into the kind of people which are affected by this, because a lot of people is affected by that. If you check your monthly payment of the mortgage, and you see that they never change, they never go down, even though you can see in the TV that the Euribor is now, I think, about 0.5, something like that, 0.5. You really may check the mortgage deed, because you probably have this abusive clause which may be removed, which might be removed, in which you will get a lot of benefits, especially considering the long term of this kind of mortgages. So that is essentially what I wanted to tell you, and just to remind you that there's a huge benefit that you could really get if you check and defend your rights. And if you don't expect the bank to send you any kind of letter removing the clause. Thank you very much.